The Law and You. A look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You. Presented by lawyer panel P.R Campbell QC. And brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another presentation in this public service nation-building series, The Law and You. This is program number 825, coming to you on Monday the 9th of May 2016. On this program, I will speak to you on the topic, the Appellate Process. But before getting into the topic, a few preliminary remarks, beginning with condolences to all families which have suffered recent bereavements, and in particular, those families which have suffered bereavements by way of homicide. I can imagine what it feels to be told that a loved one has been killed. So my deepest condolences. Condolences also to the family of my late friend, Miss Mitty de Grads of Redemption Chap, was laid to rest yesterday. Unfortunately, I couldn't make it to the funeral by virtue of having a Mother's Day function to attend. And speaking of Mother's Day, belated Happy Mother's Day to all, particularly those of my own household. Now let me remind you that there will be no program of The Law and You next week Monday, because next week Monday will be Fisherman's Day. So the next program of The Law and You would be on Monday the 25th of May DV. Okay? And speaking of The Law and You, we have now passed our 19th year in existence, and we are now into the 20th year, well, 19 plus. And I hope that if the good Lord spares, that we will do something special for the 20th anniversary. That will be next week, April DB. All right? So without any more ado, I would like to get into the program for the evening, the Appellate Process. Now, the legal system recognizes that mistakes can be made. And in most legal processes, mechanisms have been put in place to try to correct mistakes whenever they are made. After all, human beings are mere mortals. We are all fallible, that is, we are capable of making mistakes. And the system, in most cases, has built-in mechanisms to enable a person who has had a decision from one forum and is not satisfied with that decision, to enable that person to be able to appeal to a higher forum. In our system, we have magistrates' courts and, of course, the family court, and one can appeal decisions in those courts to the Court of Appeal, the Eastern Caribbean Court of Appeal, which travels throughout the OECS territories and comes to St. Vincent usually 3 times a year. They were here 2 weeks ago, as I had indicated to you. When the Court of Appeal sits, it sits with a panel of 3 judges. Now, it isn't every decision that a litigant doesn't like that the litigant would be advised to appeal. And just for completion's sake, I did mention the Court of Appeal hears appeals from the Magistrates' Court and from the Family Court. It also hears appeals from the judges. In the higher judiciary, we have a judge. Then above that judge, a Court of Appeal. and above the Court of Appeal, the Judicial Committee of the Privy Council, which sits in London. Most cases decided by the Court of Appeal would go or would be capable of going before the Privy Council, but very few cases, in fact, go to the Privy Council from St. Vincent and the Grenadines for a number of reasons. So it's the High Court judge, the Court of Appeal, and the Privy Council. As you ascend the ladder of the appellate process, the going gets harder. Now, appeal processes are hinged with technicalities. Firstly, there is always a time period which places a limit on when an appeal can be lodged. And those time limits are set by statutes, acts of Parliament. So in some cases, a person might have 14 days to lodge an appeal to the Court of Appeal. In some cases, the person might have 6 weeks to file an appeal. So the first thing that a lawyer involved in an appeal has to make sure is that his or her appeal is filed within the time limit. You may ask, well, what happens if the time limit passes? Well, in most cases, one can apply for permission to appeal out of time. That is, if the date for appealing has been missed. Usually, the party who wanted to appeal and has missed the date could apply to the court for permission. We lawyers call it for leave, to enlarge the time within which to appeal. In other words, they're saying, look, sorry, I am a few days late or a few weeks late or a few months late for this and that reason. I would like the opportunity to appeal, notwithstanding the lateness. But in order to benefit from the leniency of the Court of Appeal, one has certain criteria to face. In most cases, one has to explain why is it that one was late in filing the appeal. And in addition to saying why you were late, you have to show that no undue prejudice would be caused to the other side if you got permission to appeal out of time. And above all, you have to show that your appeal has some substance. In other words, you have to demonstrate that on the face of it, you have a good arguable appeal. If the appeal court looks at the documents and realizes, look, even if you get permission to appeal out of time, that appeal would be hopeless. You don't have any points to make that would cause the decision you're appealing against to be set aside. Then no matter how good the reason you had for being late, the court would say, look, it's going to be a waste of time because you're going to lose the appeal in any event. So why give you permission to appeal out of time if your appeal is hopeless? So you really have to come strong. And the longer the period of delinquency, the stronger you have to have with your reasons for having been delinquent. Again, there is clear guidance from the decided cases as to the circumstances in which one would be allowed to appeal late, that is, out of time. Because the philosophy of the law is that if a mistake has probably been made by the forum from which you are planning to appeal, then a litigant ought to get every reasonable opportunity to have that mistake ventilated, looked at, analyzed, and if justice is in favor of the appellant, then the court will be more ready to grant leave to appeal. When you appeal, the person who files the appeal is known as the appellant, and the pronunciation varies. You could say appellant or appellant. And the person against whom the appeal is brought is called the respondent. Now, because the appellate process is entirely statutory, that is, based entirely on written acts of Parliament, there's no such thing as a common law appeal. You have to follow the procedures laid down in the Enabling Act very, very scrupulously. So if you run foul of some of the technicalities, you wouldn't stand a chance of having the appeal succeed. Those of you who go to listen to appeals being heard before the Court of Appeal here in St. Vincent and the Grenadines would notice something which you might find strange. You will just hear the lawyers making presentations. It is rare for the Court of Appeal to hear a witness giving evidence, because the evidence given before the judge or the magistrate or the family court would have been written down, placed in documented form, bundles of document called a record of appeal, and the appeal judges merely read what happened in the court from which the appeal is coming. So the appellate process involves lawyers almost exclusively. Lawyers make presentations based on the documents generated from the court below. Court below means the court from which the appeal is coming. So that most appeals have to do with points of law, issues of law. There are well-known rules which say that if the magistrate or the judge or the president of the family court has made findings of fact, and those findings of fact are challenged on appeal, you have to come very strong to succeed in challenging findings of fact. Because the traditional wisdom is that the judge below has seen and heard the witnesses, has had the opportunity to assess their credibility and other factors, and if the judge below has made certain findings of fact, then those should not be disturbed by the Court of Appeal. On rare occasions, the Court of Appeal may disagree with the judge on findings of fact, but one has to come very strong to persuade the Court of Appeal to depart from findings of fact by the judge. And for the rest of the presentation, I wouldn't bother to say magistrate and family court. Let us deal just with the judge of the High Court and the Court of Appeal above it. So the judge has decided certain matters in the case, and one is dissatisfied, one has lost the case, and one wants to challenge that decision. In many, many cases, one has the right to appeal, the right to challenge. In some cases, if the matter is not a concluded case, because those of you who have been involved in a High Court case would know that High Court cases have different stages, different procedural hurdles which have to be overcome. And one may get an adverse ruling from the judge on a procedural matter within the case. One may wish to appeal that. It doesn't mean that the decision will determine the whole case, because the whole case hasn't been heard as yet. But the judge may rule against you on a point of procedure, and you may feel strongly about it, you may feel the judge has been wrong, and you may want to appeal against that point of procedure. Now, if you want to appeal against points of procedure which do not determine the matter finally, you have to get permission, usually from the same judge, although you could get permission from another judge in certain circumstances, to appeal. In other words, you are looking for leave to appeal. But when the case is finished, when the judge makes a final decision, then you have the right to appeal against a final decision of a judge once you are within the time limit. So that when you go before the Court of Appeal, you're really arguing law. You would be alleging that, okay, the judge made certain findings of fact, but the judge applied the law wrongly to those findings of fact and other things. And you have to try and persuade 3 judges of the Court of Appeal that the judge was wrong. Now, a lot of people seem to think that, okay, this judge in the Court of Appeal served together with this judge in the High Court. They are extremely good friends. They work together so that if you appeal against that High Court judge and that judge's good colleague with whom that judge is thoroughly familiar is on the Court of Appeal, then you may say, and some people make the mistake of saying, well, the judge in the Court of Appeal is going to side with his or her friend. It doesn't work that way at all. Judges approach their work seriously. Friendship doesn't matter. So no matter how much you know that 2 judges have been close, one in the Court of Appeal and one in the High Court, if an appeal goes to the Court of Appeal judge from his or her friend in the High Court, it makes no difference. The Court of Appeal, the one in the Court of Appeal, would apply strict rules to that decision and will not hesitate to overrule his or her closest friend if need be. And that is how the legal system functions. Just like you may have 2 lawyers who are very, very close friends appearing against each other before the judge. And you may see them conferring, chatting with one another. You may even see a lawyer giving another lawyer a lift in his motor car. Don't jump to the conclusion that your lawyer is selling out your case because he is too friendly with the lawyer for the opposite side. When lawyers come to do their work, they take their work seriously. Friendship doesn't matter. They make their presentations, they make their objections, they argue their cases regardless of friendship with an opposing lawyer. So don't jump to the conclusion that lawyers are selling out if you see them particularly friendly. And the story is told of a lawyer or 2 lawyers who went to the magistrate's court in Georgetown in the same vehicle, because one lawyer had his vehicle broken down the same day or the day before and decided to take a ride with the other lawyer, and both were on opposite sides of the same case. And when the client of one lawyer saw his lawyer coming out the same car driven by the opponent's lawyer, he upbraided the lawyer. How could you be riding with so-and-so and he against me? But that is misguided. Lawyers who have their work to do their work. And the friendship doesn't enter into the picture. In fact, sometimes it operates on the reverse. A lawyer wants to do best against his closest friend so that when they're together socializing, he would have bragging rights over his close friend. But to get back to the appellate process, I said before that some cases decided by the Court of Appeal can be taken higher. They can be taken to the Privy Council in London. But there is one thing about Privy Council cases. You have to get leave to appeal. Even though you have the right of appeal, you still have to pass a hurdle, because the Privy Council gets a lot of applications for the hearing of appeals, but they have a sifting process. So they have to decide if this case is worth troubling them. So they don't take any and any case. But if they're satisfied that the appeal has arguable points, then they will entertain it. Not if they are satisfied that the appeal will succeed. But they may want to clarify points of law for the guidance of courts in the system from which the appeal would have come. There is one particular kind of litigation which cannot go to the Privy Council, and that is, you cannot appeal against a ruling by the Eastern Caribbean Court of Appeal on election petitions. So the Privy Council in London can have nothing to do with election petitions, whether they come from Trinidad and Tobago, Barbados, the OECS, Jamaica. Well, Barbados no longer goes to the Privy Council, because our electoral law, in fact, our Constitution, says that appeals cannot be made to the Privy Council from the Court of Appeal on disputed elections. So we have currently some election petitions before the court. If in due course they reach the Court of Appeal of the Eastern Caribbean Supreme Court, whatever the Court of Appeal decides, that would be it. You cannot go any further with those. But in most other cases, you have the right to go up to the Privy Council. Now, speaking of the Privy Council, we in the Caribbean, as everybody knows by now, we have our CCJ, our Caribbean Court of Justice. But only some of the countries of the Caribbean have cut off appeals to the Privy Council in London. Most of the other jurisdictions still have appeals to the Privy Council. In recent times, there have been statements coming out of St. Lucia, out of Dominica, out of Jamaica, that they are contemplating, or there has been some agitation for moving appeals entirely from the Privy Council. That is a subject on which I have spoken at length, and perhaps one of these days I would revisit the controversy as to whether we should cut off appeals to the Privy Council. Some people feel extremely strongly that we should not. Others feel equally strongly that we should stop sending appeals to London. It gets a little embarrassing when the British judges, in dealing with an appeal from the Caribbean or any part of the world from which they still take appeals, when they say, look, these matters are best left to the local judiciary. Because what they're really saying is that you are in one cultural system about which we know nothing, and therefore you should resolve these issues in your domestic courts. Well, when that happens, everybody feels a little bit aggrieved and you want to hang down your head. But as I said, in one of these programs, I will go into the arguments for and against the Caribbean Court of Justice. But let me remind you, for the sake of completion, that the CCJ is the court in which disputes over the Caribbean Common Market, the OECS, the Caribbean Community, our economic arrangements, all disputes having to do with those matters go before the CCJ. We are just speaking about appeals from the several courts of appeal going to the Privy Council. Some territories send appeals to London and some don't. Finally, if you have a lawyer doing a case for you and you lose, you may feel very, very strongly that you want to appeal. It is up to the lawyer to advise you if you have good grounds on which to base an appeal. It isn't because you feel strongly that you should appeal that the lawyer is going to agree with you. The lawyer may feel, well, we're not happy with what the judge decided, but the judge cannot be said to have got the law wrong. I know when lawyers tell clients that, they get annoyed and figure the lawyer sell out and they go into another lawyer because they want to appeal, they want to appeal, they want to appeal. Well, if you don't have reasons to appeal, you'll be wasting money and time. So I would ask you to be guided by your lawyers. And there's nothing wrong with asking a second opinion if you feel strongly about it. But if your lawyer says, look, as disappointed as you are, we have to accept the decision and move on, follow your lawyer. The lawyer knows the rules, okay? So that is all for this program of the Law and You, the Appellate Process. Do have a successful and happy Fisherman's Day on Monday the 16th. And if it be the will of God, we'll see you back on the 25th for another presentation in this public service nation building series, The Law and You. May the good Lord continue to bless us all.
The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.